Welcome to This Explainer. Okay, we're diving right into the ultimate constitutional rulebook today to ask a pretty terrifying question. What actually happens when that rulebook breaks its own rules during a crisis? We're going to map out exactly how the Constitution navigates the insane tension between state power and your individual liberty when a national emergency is declared. So, let's see how this legal pendulum swings.
To kick things off, think of a constitutional emergency as basically an in case of emergency, break glass protocol. Specifically, we're looking at Articles 352 to 360 in the Indian Constitution. These are special mechanisms designed to protect the nation, but they do it in a really dramatic way, by temporarily suspending normal constitutional operations and shifting a massive amount of power directly to the executive branch. But here's the catch. When you hand over that kind of sweeping power, the question of who holds the hammer and who's watching them becomes absolutely crucial.
So our explainer today is broken into two main acts. Act 1 covers the battle for the states under Article 356, and Act 2 takes us into the profound battle for human liberty under Article 359.
All right, let's jump straight into Act 1, the battle for the states, focusing on Article 356, which is commonly known as President's Rule. To really understand how this plays out, we've got to go back to the intense political turmoil of 1977. So, a new central government had just swept into power after national elections, and they immediately sent out advisory letters threatening to dissolve 6 state assemblies simultaneously. They basically told those incumbent state governments, hey, go get a fresh mandate from the public or face Article 356. Understandably alarmed, those states marched straight to the Supreme Court in the landmark State of Rajasthan case, desperately seeking an injunction to stop the center. Now, the Supreme Court, they initially hesitated to step in. They ruled that the president's satisfaction, meaning the executive's conclusion that a state government was failing, wasn't ordinarily something the courts could review. They said, we can't easily restrain an executive action before it even fully happens. But, and this is a big but, they left the door open just a crack. They noted that if obvious bad faith, what lawyers call mala fide actions, could be proven, the court actually retained the right to strike it down. And that slightly open door brings us to this incredible quote from Justice Bhagwati in that very case. He makes it crystal clear that no authority is the sole judge of its own power. He's planting a massive seed here. Sure, the executive has brought emergency powers, but the court is still the ultimate referee. Now, this idea laid somewhat dormant for a while, but it was absolutely essential groundwork.
Which brings us to a total game changer. Fast forward to 1989 and the S.R. Bommai case. Karnataka's chief minister, S.R. Bommai, was dismissed by the governor, even though Bommai claimed he still had the legislative majority. The crazy part? He wasn't even given a chance to prove it on the assembly floor. This blatant overreach forced a massive 9-judge bench of the Supreme Court to finally draw a hard line in the sand.
That 9-judge bench laid down a brilliantly strict framework to stop this kind of abuse. Step 1. President's Rule requires objective material. You can't just guess that the state machinery has failed. Step 2. A floor test in the Legislative Assembly is the only appropriate way to prove a legislative majority. No more guesswork by governors. And Step 3. To prevent irreversible damage, the national parliament has to approve the move before a state assembly can be fully dissolved. This was a colossal win for federalism. And we see this strict framework put to the ultimate test during the 2005 Bihar Assembly crisis in the Rameshwar Prasad case. Imagine this. After an election, there's a hung assembly, no clear winner. The governor gets worried about unethical horse trading between politicians and recommends dissolving the assembly before it is even met for the very first time. President's Rule was slapped on immediately, and politicians obviously challenged this preemptive strike.
You can really see how much the court's stance had evolved since the 70s. They completely struck down the president's proclamation, calling it unconstitutional. Why? Because the governor's actions were based entirely on conjecture and mere suspicion and unproven assertion the court called his personal ipse dixit. They basically said, look, Article 356 is an emergency power, for sure, but it's not an absolute power you can just throw around because you suspect foul play. You need concrete evidence.
All right, moving right into Act 2, the battle for human liberty, where we look at Article 359. The constitutional stakes are about to shift dramatically from state governments to individual human life.
To really grasp what happens when the chips are down, we need to look at the 1964 Makhan Singh case. It's all about a super important legal distinction. See, under Article 358, a fundamental right is expressly suspended, completely gone during an emergency. But Article 359 does something totally different. It only suspends your legal remedy to enforce that right in a court. So technically, the right still exists in the background. You just can't ask a judge for help.
And Justice Subarao really hit the nail on the head regarding this distinction. He pointed out, quite logically, that if the framers of the Constitution meant for these two articles to do the exact same thing, they wouldn't have bothered writing two different articles, because the suspension of a remedy doesn't erase the right itself. It means if the executive goes rogue and steps outside what the law strictly allows, citizens theoretically still have a leg to stand on.
This highly technical distinction completely sets the stage for the absolute darkest climax in our explainer, the infamous 1976 habeas corpus case, ADM Jabalpur v. Shivakant Shukla. This is the moment where the theoretical limits of constitutional emergency powers violently crashed into reality.
The context here is just wild. India was operating under unprecedented dual emergencies, an external one from 1971 and an internal one from 1975. In the middle of all this, presidential orders dropped that officially suspended the right of any person to move the courts to enforce their fundamental rights. We're talking Article 21, the literal right to life and personal liberty. People were being scooped up under preventative detention laws, and when they went to the high courts just to ask, why am I here, well,
They ran straight into this devastating majority ruling from the Supreme Court. 4 out of the 5 judges declared that citizens had absolutely zero legal standing, no locus standi, to challenge their detention. It didn't matter if you claimed the detention was 100% illegal, arbitrary, or based on a personal grudge. The highest court in the land ruled that the courthouse doors were legally locked shut.
So how on earth did they justify this? The majority argued that Article 21 was the sole source of your right to life and liberty. Their logic was that if the executive suspends Article 21, your right basically evaporates. They claimed there were no natural, pre-existing rights you could rely on outside the Constitution. In fact, they controversially stated that liberty is merely a gift of the law, meaning what the state gives, the state can just take away during a crisis.
But, thankfully, there was one dissenting voice. Justice H.R. Khanna delivered a legendary dissent that is still studied all over the world. He completely rejected the majority's view, arguing that the sanctity of life is a universal human value that evolved with civilization itself. It is absolutely not some mere gift handed out by a legal document, and therefore an emergency decree cannot just erase it.
Khanna forcefully broke it down like this. Even if your constitutional remedies are paused under Article 359, the state still can't just illegally deprive you of life or liberty. Why? Because statutory laws, the regular laws passed by the legislature, are not suspended. A presidential order can't just nullify a statute. If the executive breaks a normal law to detain you, they are acting without authority. The rule of law doesn't just vanish into thin air, emergency or not.